Good morning, everyone. Just as a matter of housekeeping, mobile phones please turned off. And welcome to the latest in many Michael Green Wills and Estates Succession Law series. My name is Georgina Grigoriou. I've been a barrister on Michael Green's list for most of the 26 years that I've been at the Victorian Bar. And the reason I've stayed on this list is basically because of Michael Green and the values that he has. I'm a working mum, I've got two teenagers and I have a husband that works, and Michael Green for me has provided the service, the loyalty, tinged with a bit of humour along the challenges that we all have in our professional lives. So it's not a plug for Michael, but it's how I genuinely feel about the list and the staff. He really looks after his staff, and I think that's what we should all do when we're running small businesses. We should look after our staff because what we give, we get it back in bucket loads. All right, I'm chairing this seminar this morning on succession law and elder law, something that's very, very dear to my heart as a wills and estate practitioner. And looking around the room, and in fact last night I was lying on the bed looking at the list of attendees and reading. I did read both papers, and again I see an interesting mix of people here today attending these seminars. You've got what I call the sort of stalwarts, the wills and estate specialist, David Hughes. You've got Barry Fry. I saw Barry walk in. Morning, Barry. These sorts of practitioners have been around for a long, long time. They have a myriad of clients and they are statesmen in this area of the law, and I do implore the young ones, particularly I see quite a few female members from Michael Green's list. Welcome. I think it's really, really important for the young ones and not so young ones to always take ideas from the more senior practitioners. I see Peter Connor, country solicitor here, which is good to see, and a good contingency from Moore's Legal also. All right, elder law and succession law is really about people, and it's about the interrelationships that people have. And that's why in the area of work that we all work in, we're dealing with relationships, we're dealing with people that meet, that marry, don't necessarily marry these days, that live together, good morning, that live together, that have children, that buy property, that build up a superannuation fund, that might lose capacity along the way, as no doubt John will talk about, and have issues regarding their property, as Eleanor will talk about. And in the end, we all tend to die. And that's where you all come in with your expertise. And while lying on the bed last night, my daughter came in to me and said, "What are you doing, Mum?" And I told her that I was doing this seminar this morning. And she said, "Oh, you have to tell them that funny story that Henry Azen, who's been at the bar for about 45 years, told Dad and you a couple of years ago." And she Googled, as a 16-year-old does, in about 2 seconds, she Googled this story. I also see Anne Gambetta here, another stalwart. Morning, Anne. And this story really epitomises the sort of work we do. People we meet, the issues they have, the legal issues they have, and then they pass away. And it's about this old man and this old lady. And you've probably got lots and lots of these clients, because I certainly do, and I know Eleanor and John has. And the story is very simple. A man and his ever-nagging wife went on vacation to Jerusalem. While they were there, the wife sadly passed away. The undertaker told the husband, "Well, you can have her shipped home to Melbourne for $5,000, or you can bury her here in the Holy Land for $150. The man thought long and hard. He thought about it, and he told the undertaker he would just have her shipped home. But the undertaker asked, "Why would you spend $5,000 to ship your wife home? when it would be wonderful to be buried here and you can only spend $150. Ah, the man replied, and I quote, "Long ago, a man died here, was buried here, and 3 days later, he rose from the dead. I just can't take that chance." That was a good story. All right. The first speaker today is Eleanor Coates. You've all read Eleanor's profile, self-explanatory. I first met Eleanor, I think, when my now 18-year-old son had just been born, and she had briefed me in a matter. And we have developed a professional and a personal friendship over the years. And I'm delighted that she has come to the bar, taken the step, and in particular come onto Michael Green's list. Eleanor has always had a very good wills and estate practice. When she was at Kenner Teesdale, she ran the wills and estate department. Interestingly, some of you may not know this, but Eleanor is very experienced in criminal law. She started work with Tony Hargraves, who for years has acted for the Police Association and a fine legal practitioner. And she's done a lot of work in the criminal sphere, which I think bodes her very well in terms of doing trial work, in all sorts of trial work that she may do. She is an accredited mediator and is quite a good mediator. So, ladies and gentlemen, Eleanor Coates.
Good morning. Thank you, Georgina, for that introduction, and thank you everyone for getting out of bed and making it here. Like Georgina, I'm a working mum, and I deposited my 6-year-old and 4-year-old on somebody's doorstep at 6 o'clock this morning, so in absence, thanks to my friend as well. I'm talking about Ademption this morning, and I'm not talking in depth about the laws of Ademption, but rather the VLRC review on the laws of Ademption. And what I'd like to cover is a brief overview, then talk about sale of property by an administrator, sale of property by an attorney under power of attorney, because the situations in Victoria are currently vastly different, have a quick look at some other minor reviews that the VLRC have recommended, and then just finish up with a couple of tips and tricks and things that you could look out for unless and until those laws are reformed. So what is Ademption? I'm sure most of you here know what Ademption is, but in brief terms, it's disposing of an asset during a testator's lifetime. And obviously upon disposal, the gift in a will can no longer take effect of that asset. So a classic example of Ademption is a testator sells their home to move into care. They've given that home specifically to someone under their will. Upon their death, that gift can't take effect. Now, currently, the common law sets out the rules of Ademption. There's no legislative provision for it in the Administration and Probate Act. So what the law will do, what the court will do when faced with the question of has a gift been redeemed, is the first question they will ask is there a gift of specific property? So my home situated known as whatever that property is, or my Ferrari registration ABC123. They will then look in the estate and say, righto, if it was specific property, does it still exist? And obviously if the answer is no to those questions, then the gift has been redeemed. So the law of Ademption applies to specific gifts only and not general gifts. The VLRC has reviewed the laws, and what they've said is that there are reforms needed. So despite that walloping book, nothing quite like the Guardianship book, but the succession laws, there's a lot of laws that may change. Ademption is one I am confident will change in light of these reviews. What the paper does is it sets out a really good example of Ademption, and it works through that example in different scenarios and how the law is and how the law might be. And the example given is that the testator owns 2 units. One is his home unit that he lives in, and he leaves that in his will to his daughter. The second is an investment property that he leaves to his son, so they're both equal value. He leaves his residuary estate to his grandchildren. So during his lifetime, whilst he's fit and well, Mr A sells his unit and moves into a home. The proceeds have gone into a nursing home bond, and then he dies. Now, under the common law, Mr A was fit and well when he sold it. He's presumed to have known the contents of his will, and so the gift has been redeemed. The nursing home bond will go to the grandchildren as part of the residue because the house isn't there. The son will get the investment unit, and the daughter will get nothing. So what the VLRC has said is, well, that's good, it's nice and simple, it's easy to follow, but it's very inflexible. So to avoid unfair outcomes, the common law has developed a number of exceptions, and I've set them out very briefly in the paper, and this is really by way of general background. The court will try and presume that a gift is general rather than specific if it can. So if you give X percent of the home, the court will assume that's a gift of value and money rather than the home. The court will look to see, well, perhaps the property's changed in name and form only, so bank account, the proceeds of my bank account might have moved into another bank account and it can still be retained. And there's also an exception for the wrongful act by a third party, so that could be a tortious act, it could be an unauthorised act, an attorney acting outside their power. I don't deal with the law in any more detail than that. Andrew Verspendonk, also on our list, has prepared a wonderful paper on Ademption. I don't believe it's currently on the Greens List Library, but he's given permission for that to occur. So I thoroughly recommend, if you want an in-depth discussion on the law of Ademption, to look up Andrew Verspendonk's paper. But with these issues in mind, the Commission has looked at ways to reform the law without creating more litigation, because sadly we don't need that, even though we'd probably all like that. But they don't want to prolong and have disputes before assets are sold so that ademption can be avoided. So they've looked at ways to reform the law. The first area that the VLRC looked at was administrators appointed by VCAT. And as I indicated, the situation is very different between an administrator and an attorney. Now, there is a hideous typographical error on page 3 of my paper. It says, the law is clear that when an administrator has been appointed by VCAT, if an administrator has been appointed by VCAT, it says, then if the attorney, that should be administrator. This applies only to administrators. Sold the property, there is a legislative exception to ademption. Now, that's set out in section 53 of the Guardianship and Administration Act, and it's important to note that there is no such exemption in the Instruments Act. So this applies only to attorneys appointed by VCAT. And for today's purposes, it's only really subsections 1 and 3 of this section that are relevant. So what subsection 1 provides is that a represented person, and then relevantly, his heirs, executors, administrators, next of kin, devisees, legatees and assigns have the same interest in any money or other property arising from or received in respect of any sale and so on or disposition under the powers given to an administrator by order of the tribunal. So what that means is it will save a gift from ademption where it's been sold by an administrator. Now, 2 talks about compulsory acquisition. Subsection 3 is important as well and is also the subject of review, and that refers to an administrator receiving money or property under this section, so the gift that might be deemed, keeping a separate account or record of that money. 4 and 5 again aren't that interesting for today's purposes. It just talks about general power of investment and that these laws apply upon intestacy as well as a will. Now, as I indicated, there's no such exception like that in the Instruments Act. So what the VLRC did is they've looked at pretty much 4 areas of this section to say, well, there's things even within this system that need to be improved. So they've looked at when an application will result in an unjust outcome, the treatment of income, because it's quite unclear what that section means about any income or interest earned, account keeping obligations, and whether it matters that the represented person had testamentary capacity at the time the gift was disposed of. So looking first at unjust outcomes, the VLRC looked at the laws interstate, and they looked in New South Wales where there is legislative provision for, in that case, attorneys rather than administrators, which talks about affected beneficiaries having the ability to apply to the court to alter the effect of the legislative exception if it becomes unfair. In South Australia, it applies to both administrators and attorneys, and in Queensland, instead of applying for a readjustment of the estate, a person applies for what they call compensation, which is really just another way of saying a redistribution, because that compensation comes within the estate. And what Victoria has recommended is that the disappointed beneficiary can apply to the court for an adjustment, and they can do that if there is an unfair result either because of the legislative exception or despite the legislative exception. So going back to that example of Mr A and his 2 units, what the VLRC looked at was a disproportionate result notwithstanding the legislative exception. So say the administrator sells the unit to put Mr A into a home and uses all of the proceeds of sale on his care. So the bond is completely consumed during his lifetime, and it means even though there's an exception to ademption under the law, there's still nothing there for that beneficiary to get, so they can, under this proposal, go off to the court and apply for a redistribution. Now, it's interesting, you think, OK, well, they might have rights under Part 4, but what it seems is that you don't need to demonstrate a need for an adjustment. This is a question of fairness, unlike Part 4, which is a question of need and obligation. So in this scenario, the daughter, who was to benefit from the home unit, despite any needs, could go off to the court and say, hey, that's not what Dad intended. The will demonstrated we were going to get one each. I'd like a readjustment, thank you. The other example that the paper gives is a disproportionate result because of the legislative exemption. So say instead of a second unit, Mr A has his home unit and he has an investment portfolio of shares. The home unit is sold, the proceeds of sale go into a bond and the bond isn't touched, but the investment and shares are sold up and used for Mr A's care during his lifetime. So at the end of the day, the exception kicks in, the nursing home bond goes to the daughter, but the rest of the estate's gone because it's been used up in Mr A's care. So what the court says, or the VLAC proposes then, is the son in this instance says, well, because of the exception, I've got nothing, and he can go to the courts and seek a readjustment, again, not dependent upon his needs, but just on the general intent of what the testator intended. So that's the sort of, I guess, a fairness approach that the VLAC are considering to avoid unjust outcomes in cases of ademption where there is a legislative exception. They've then looked at the treatment of income generated by the sale proceeds, and you might remember 53(1 talks about any money or other property arising from or received in respect of the sale. And it's not entirely clear whether that includes interest earned on money invested, income on substitute property or anything like that. The VLRC looked at the New South Wales situation where there was a similar provision referring to surplus money or other property arising from the sale. And that was considered in RL and New South Wales Trustee and Guardian and the citations in the paper. Now, the court didn't need to look at that issue in this particular case, but what they did say was, well, hypothetically, if we needed to look at it, in our view, a beneficiary would be entitled to any interest, and that the phrase surplus money would cover income or interest earned. And what they said was, well, that makes sense because had the beneficiary received the gift itself, the gift probably would have evaluated over time, so they should take that increase in value by way of income or interest. So what the VLRC has recommended is clarifying exactly what 53(1 means to confirm that the beneficiary of an deemed gift will receive any income or interest earned on the proceeds of sale, but obviously less any amount that has been used towards the care of the represented person. The VLRC then looked at the record keeping, and you'll remember I said 53(3 was the other section that had any relevance today. And what that says is that an administrator should keep a separate account and record of money. But what does that mean? Does it mean they quarantine it? Does it mean that they use it sparingly, they use it as a last resort? So, again, given that there's some confusion as to exactly what that means, the VLRC has recommended that that section should be repealed and replaced with a clear version that makes it utterly beyond doubt that the money does not need to be quarantined and does not need to be accounted for separately, because you'll remember that an administrator appointed by VCAT has record-keeping obligations anyway, and so those record-keeping obligations will cover the proceeds of sale and make it easy to untangle an deemed gift if need be. And obviously they shouldn't be needing to worry about quarantining these monies. If it's in the best interests of the represented person to deal with the asset, then that's what they should do. Their duty is to the represented person and not to the beneficiaries, So they shouldn't really need to have heed to the rules of ademption. What they should be doing is acting in the best interests of the represented person, selling whichever asset it is that is appropriate and applying the funds in the best interests of that person. So what they've said is, forget keeping it separate, forget separate records, just act in their best interests, and they want the legislation amended to confirm that that's the case. Lastly, they looked at capacity and whether Section 53 should apply, whether the represented person had testamentary capacity at the time or not. And what they said is, and it's important to remember, a person can keep their testamentary capacity even if they've lost the ability to look after their day-to-day affairs. If they have simple matters and a simple estate, then they may have sufficient capacity to prepare a simple will. So they may have testamentary capacity even though they have an administrator appointed. So again, if you are dealing with someone who's under an administration order, think about whether they still have capacity to alter their will. It may be that they do if it's a simple will. But what the VLRC has said is it doesn't matter, and legislation should be clear that it doesn't matter whether the represented person had capacity or not at the time the sale took effect. Section 53 applies. Just makes it simple. There's no need to then go back in time and ascertain did they or didn't they have testamentary capacity at that time. The VLRC then looked at acts by an attorney. Now, the current law is in a real state of flux, and the VLRC have recognised that, and as such they've said, look, this is in need of serious reform, and it's my view that this is one of the reforms that will take effect hopefully sooner rather than later. So as I've explained earlier, there's no equivalent in the Instruments Act. So if a sale takes effect by an attorney instead of an administrator, you go back to the common law. Now, we've already run through the exceptions. So again, remembering general gifts are not deemed, so the court will try and make a gift general rather than specific if they can. They'll try and follow a gift, or to use the term loosely, trace it if it's only changed in name and form. And again, if it's an attorney acting outside the scope of the power of attorney, it's an unauthorised act. So again, ademption doesn't apply. Now, in Simpson and Cunning, which was a 2011 decision, Justice Hargrave looked at this issue in some depth. And he actually said in his judgment, look, there's some real problems here. And he referred his judgment off to Parliament and said, you need to do something. We're 3 years down the track, and unfortunately at this stage nothing's happened. Now, in that case, His Honour tried to extend the common law, and at the moment it's good law in Victoria, but there's interstate Court of Appeal judgments that say it's not good law anymore. So what Justice Hargrave said is, if a will maker lacks testamentary capacity at the time of the disposal, and if the court is satisfied that if they had capacity, they would have altered the will because they would have intended the donee to retain the proceeds of sale, and if the remaining proceeds of sale can be identified, then they will save the gift and give the proceeds of sale to that beneficiary. So again, using the example of the unit, it would be quite easy for the daughter to say, well, look, Dad had lost capacity, so I sold the unit, so we've ticked number 1. Dad wanted us to be treated equally, so we've ticked number 2, and look, here's the nursing home bond. You can ascertain what the proceeds of sale are. We've ticked number 3, and I get to keep the proceeds of sale. The problem, as I indicated, is that Justice Hargrave in his decision relied on a Queensland decision re Viatel, and Andrew Versmondong's paper goes into enormous detail of this, so forgive me for glossing over it. But that decision has been variously followed, as in Simpson and Cunning, but then it's been not followed, even in Queensland, where it originally came from. So the only Court of Appeal to look at this was in New South Wales, in that case that I mentioned earlier, in RL and the New South Wales Guardian and Trustee. Now again, the court didn't need to look at this issue because there is already an exception in New South Wales for for attorneys, but they decided to take it off and have a look at it. And unfortunately, they decided Justice Hargrave's decision was morally correct, it was a good result, but it was wrong in law. So it means that as far as New South Wales Court of Appeal is concerned, Simpson and Cunning is no longer good law. And what the judgment said was that the exception doesn't apply. It's trying to extend the common law beyond its reach. And unfortunately, a judge sitting in the New South Wales Court of Appeal had previously said re Viatel was good, changed his mind and said, well, actually, it's not good anymore, I've changed my mind. So there is real uncertainty in what was previously considered to be an exception to Ademption. So the recommendation is that because of this real uncertainty about what happens when it's an administrator acting, that something similar to Section 53 should be put in the case of attorneys. They've said similarly there's no need for additional account keeping records for attorneys because they're required under the Instruments Act to keep records anyway. They don't need to keep the funds separate. They don't need to account for them or keep separate records. Again, they've looked at the issue of capacity and remembering that subject to the terms of a power of attorney, that the attorney can act concurrently. So there's no need for the testator or will maker to have lost capacity for them to have conducted the sale. And what the recommendation is, it doesn't matter whether they had capacity or didn't, because it would just, again, result in unnecessary litigation trying to ascertain down the track whether there was, in fact, capacity or not. And note the time, so just skipping over, what they've said is the section would look very much like Section 53 with the proposed amendments. Again, a disappointed beneficiary could go to the court seeking an adjustment. There's no need to keep records. There's no need to keep the proceeds of sale separately. And it doesn't matter whether or not the testator had testamentary capacity at the time of the disposal. So the VLRC didn't suggest a reform to the common law. They didn't suggest codifying it and putting it in legislation to make it clear. They've just said, look, we'll clarify the issues with attorneys, we'll tweak the issues with people appointed by VCAT. They looked quickly at the issue of access to wills and ultimately determined that if you need to know what's in a will, you can still go to VCAT and get that. There's no need for an attorney or an administrator to have a right to look at what's in a will. In the meantime, what do? Well, draft your wills carefully. Consider what might happen. Talk to the will maker. Look, if your house is sold, what do you want to happen? If they do want the gift to be redeemed, take notes, keep a record, because there may be a fight down the track. If they don't want the gift to be redeemed, then draft accordingly. If they've lost capacity, what you might want to do as a quick fix is actually get your attorney to go to VCAT and say, look, I don't want to be an attorney, I want to be an administrator. And explain to VCAT why, because then they get Section 53 and they get the protection of Section 53 that an attorney doesn't currently have. If you've got the time, consider a statutory will. If the change is simply changing that gift into the new proceeds of sale, the court will look pretty favourably on a minor change like that if you can demonstrate that's what the testator intended. And finally, if you're asked to prepare a power of attorney, have a look at the person's will now. It's a value add. The client will appreciate it. You might get the extra bit of work, but you can make sure that their affairs will take effect as they intend. So unless we're planning on any questions now or at the end, as is convenient, I know it's time for a break.
I have a question. Yes, Anne. Just raise your voice a little bit, Anne.
Sorry?
Just raise your voice a little bit, please.
The testator signed a contract of sale, subsequently died, settlement some months away, but the asset still exists, but it's under contract. Has the gift been redeemed?
It would depend on, again, the sale has taken. It just depends whether you can follow through the proceeds of sale in accordance with those current common law exceptions. So it depends on the terms of the will. If the will is specific as to a piece of property, so it's only that asset, it sounds quite likely, sort of subject to surrounding circumstances, that it has been redeemed.
Any other questions? Very briefly, I have a question. Eleanor talked about, you talked about the redistribution application that the VLRC is looking at putting in place, and you talked about fairness. Have they set up any criteria as to what fairness means? I mean, because the instructing solicitors and the barristers in this room, we're going to have to get our heads around what categories and criteria the court would take into account to, I see a few heads nodding, to whether your application for redistribution or reapportionment or whatever they want to call it is going to be successful or not.
It seems that what the VLRC will look at more than anything is what did the testator intend. Now, you can imagine, and I was actually considering this on the bus in this morning, what happens if they do the readjustment and it actually leads off to a Part 4? Because there's every chance it could, and they haven't addressed that. So, although this redistribution in theory is good, it could potentially lead to Part 4s, and one would hope in practical terms that the court would require mediation so that the whole lot can be treated together to avoid and head off potential Part 4 claims.
And you wonder whether in the giving of notice of the application, whether the applicant for the redistribution would need to give notice to any, quote, persons interested, end of quote, such as prospective TFN claimants, or if there's a widow, or if there's adult children, in the overall cocktail of relationships that people have, a bit like we have to do when we make application for a statutory will or an informal will. We've got to give notice, depending on the circumstance of the case, to people that will be potentially affected.
That seems exactly right, and it would seem to be sensible, if possible, as a practitioner, to get everyone on board, and if you can, have a mediation to try and sort out the lot. You can enter into terms without issuing a Part 4 if you need to, and you can always go off and get formal orders for stamp duty purposes if you need to, but it certainly does have that potential for creating other issues down the track.
After that interesting discussion, time a 10-minute break, everyone.